Welcome to Hurt at Work, a Kentucky workers' comp podcast. Today, Louisville workers' compensation attorney Scott Scheynost is going to provide helpful information, tips, and advice for injured workers and their families. Scott's goal is to help you to maximize the benefits you receive. If working's got you hurting, sit back and listen to Scott address topics that matter to you. Well, friends, we're back in the studio with attorney Scott Scheynost, and today we're going to ask a big question. When do you need to lawyer up? Scott, welcome back, guy.
Hey, happy to be here.
Absolutely.
Glad you lawyered up today. Yeah.
So this is kind of a common question because a lot of people don't really want to go through the legal process. They
Right.
Well, I'm not the time to sue somebody.
Right.
I don't really want to get involved.
Most people don't want to, right?
But in a workers' compensation scenario, things kind of get squirrely a little bit quicker than they may realize.
Well, yeah, depending on your situation, but my experience is that most employers know what to do in a workers' compensation claim, and most employees don't.
That's a good point.
Most employers, especially the bigger ones, they've got safety managers, they've got HR people whose job is to manage workers' comp injuries, and the way they manage those is they're essentially trying to save money, which means you're not getting as many benefits, you're not getting as much for disability, there's just a whole lot of things going on in the background. And most people I deal with, they're not in the blue-collar part of this where they're managing stuff and seeing who gets safety bonuses and trying to figure those things out. They're on the line. They're trying to make a living. They're just trying to do what's right. And they expect to be taken care of, but they get thrown into this system, and it can be a meat grinder sometimes. They get thrown into this system. They've never had a workers' comp claim before, and they're swimming with sharks.
Well, they're worried about, I don't want to get dismissed from my job because I filed a claim. They think I can't perform my duty. I mean, right. I may not be able to find another job. There's a lot of emotional attachment to the workplace.
Right.
I mean, as much as we like to downplay it, that's kind of our second home.
Well, most people, they're working to make a living, but they're also working in a place because they enjoy working there. Some people don't work at places they like it, but for the most part, most people are enjoying their work. And there is that emotional attachment. They don't want to get the boss mad at them. They're afraid of losing their job. There are some statutory protections out there. You can't get fired for what we call the retaliatory discharge in Kentucky for filing a workers' compensation claim. There's a couple other things from a statutory perspective and legal perspective that keeps the employer from discriminating against you from having a workers' comp claim, and I don't really want to get into all that because that's kind of a separate thing right now. But there are some protections out there. But what I see, and this happens a lot, and it seems like it's happened a whole lot here in the last couple of weeks, is I've had some people that were dedicated employees that liked their job and wanted to work, and they've just been managed is the best word by the employer to where the employers had the best possible outcome in the workers' compensation claim.
Meaning the employee did not.
Correct. And some of these employees may not have a job afterwards. They thought they were going to be employed, but at the end of it, they're not. They've kind of sucked it up and not had as much medical treatment and asked the doctors not to do anything because they were trying to make their employer happy. And, the irony of the whole thing is they don't have a job now. And everybody's different. Every employer's a little bit different than the others. But I think the main thing is that folks have to realize, they're working for an employer that's a business. And at the end of the day, the business is looking to make as much money as it can. And workers' comp is an expense for a business. So they have people, especially the bigger the company is, that are dedicated to keeping those workers' compensation costs down.
That's cost containment for them.
Cost containment, even though a lot of smaller companies have workers' comp insurance, their premiums can still be based on their loss ratio. People in the company can sometimes get a bonus for not having any workers' comp injuries. There's a lot of things going on in the background that have a big impact on somebody who gets hurt. That prevent them from getting what I think is reasonable care and the proper care where the folks at the company are managing the claim. The bigger companies, they're managing the claim the very first minute you report the injury. They're trying to steer you to certain doctors they know will not give you as much treatment, will not give you as many or as high an impairment rating, will send you back to work sooner. They know who those doctors are. And the bigger the companies are, the more experience they've had with those doctors. So,
right, they've just got more people.
Yeah, the very first thing about this is if the company tells you to go to a certain doctor, you really need to question that choice because there's a reason they want you to go to that doctor. Kentucky has a choice of physician law, which means the company can't tell you what doctor to treat with. And I hear this happen probably 2-3 times a week. My company said I had to go to Dr. X. Well, you don't have to go to Dr. X. You can call up the Department of Workers' Claims in Frankfurt at 502-564-5550 and confirm this. Kentucky is a choice of physician state. There's an exception to that. If you have a managed care plan, you've got to go to one of the doctors in the plan. That doesn't usually apply to an emergency situation, and there's always more than one type of doctor.
So you still get to choose within that group.
Yeah, exactly. It's like an HMO, but you get to choose what doctor in the HMO you want to go to. And even then, they can't tell you what doctor. The company can't tell you. The workers' comp carrier can't tell you. The boss can't tell you what doctor to go to. If you're being told what doctor to go to, there's a reason. And generally that reason is to save money. And, you've got to make this decision. Do I want to get better? Do I want to get myself back in the workforce in as good a manner as possible? Do I want to be taken care of, or do I want to save the company money? I think if you sit down and ask yourself that question, you're usually not going to go to the company doctor. My advice is to go to your family physician if you can. Generally, your family physician is not paid by the company to save the company money. Generally, your family physician is doing it. They're usually an underpaid doctor that does it because they're trying to make people better. So, your family physician, to me, is usually the most unbiased person out there. And, go to them, ask them if they had this injury, where would they go for treatment if you need a specialist? But avoid almost at all costs any doctor the company sends you to.
Right.
Again, you're swimming with sharks, and that's usually the first thing that comes up is the treating doctor. The company tries to send you to somebody they know will save them money. There's other things that can go on down the road, too. Generally, if the company asks you to do something in a workers' compensation claim that affects your medical treatment, there's a monetary reason for the company to do it. If they ask the doctor to send you back without restrictions, for instance, well, usually the doctor wants to make you happy, and if you tell them you don't need any restrictions, they'll send you back. But if you go back to work without restrictions, that can hurt your workers' compensation claim down the road because restrictions, that's another way we determine how much money you get out of this. And if the company asks you to go back without restrictions and you go back without restrictions, to keep your job and you get fired, well, we got a problem now.
Yeah.
Maybe they've cut you off from medical treatment because you're done treating with a doctor. Maybe you do need restrictions on your job, but the doctor you last saw him 6 months ago said you don't. Maybe they were accommodating with you, trying to, help you out. But being fired is a traumatic experience, and a lot of companies want to cut their losses. They know how to do it without violating some of these laws. They're setting people out. And I hate to say it, but it just seems like they're just whacking them over the head and they're not expecting it. Yeah. All these folks at your work do this for a living. There's some people at some plants that don't do anything but workers' compensation claims. Sometimes they have 4 or 5 people at a plant that handle all the workers' compensation claims if you've got a large plant. All these folks know a lot more about workers' compensation than you do. You got to be very careful when you're dealing with them.
Well, you expect the company to take care of you because you've taken care of the company. I mean, you've been working there for a period of time. You come in every day. You give your best effort, and suddenly something goes wrong and you get hurt. And without even realizing it, the equation changes dramatically sometimes.
Well, and the equation always is based on how much money you can make for the company. So when you're not making money for the company, somewhere, somehow, they're going to deal with that. And then it becomes a question of, well, if you're not making this money, are you going to cost this money because of this workers' compensation claim? And in general, the answer is yes. And then they're going to try to figure out what they can do to minimize that cost. And again, that gets back to less treatment, doctors that give lower impairment ratings to reduce the amount of money you get for permanent injuries, less restrictions, things like that. So, once you have a workers' comp claim and you're dealing with the HR person, the safety director, the workers' comp adjuster, their job is to take care of these workers' comp claims and save the company money. That's how they get promoted. That's how they get advanced. Some of them get bonuses on this stuff.
Right.
They may be presenting the face where they're trying to help you, but in general, the bottom line is they're trying to save people money. They're trying to save the employer money. And they're more interested in that in the long run generally than they are in trying to make you better. I have seen adjusters. I have seen HR people I have seen safety directors that actually try to help folks and get them back. Seems like they don't last very long because they're costing the company money, and you don't deal with them after a while. But once you get injured, and obviously the bigger your injury, the more important all this becomes. Because the bigger your injury, the more medical treatment you're going to have, the longer you're going to be off work. Probably the higher the impairment rating, the more restrictions you're going to get. And, all the stuff that you did at the very beginning, steers you in a certain direction towards the outcome here. That's what they're trying to do. They're trying to steer you into a direction that has less of an economic outcome to the company than anything else. But, after you've been off work, you've been gone for a couple of weeks, they tend to forget about you. If you've been gone for a couple of months, you're not the guy they used to work with. You're a guy that's deducting money from the bottom line that's costing, somebody a bonus.
Joe who?
Yeah. And 6 months seems to be a magic period for all this stuff. If you've been off work 6 months, then they're going to be actively doing things to manipulate your workers' compensation claim by sending you to certain doctors that will reduce your treatment or cut off your benefits.
Well, Scott, is the employer required to hold your job for you?
In Kentucky, the employer is not required to hold your job.
Even if you've been injured doing your job, they're
Correct,
not required.
Correct. And that's not really discrimination, because if they've got to hire somebody to come in, it's not because you were hurt at work, they need somebody to work there. So in Kentucky, the law is they're not required to hold your job. Now, you might be in a company that has a union contract that might modify this. There's certain unions that require this. Your company might go ahead and do that anyhow. But they are not required by law to hold your job.
Interesting. And
there are some things that interplay with workers' comp, like the FMLA, Family Medical Leave Act. If the company's over a certain size, and you can ask them to hold your position for a certain amount of time, but after that time expires, you're not required to hold your job. Now, on the other side of it, if they're not going to hold your job and try to accommodate you when you come back, you probably don't need to be working for that company.
Yeah,
I mean,
it's
between me and you, we won't go down that road. But
right. But I mean, it's kind of hard when you've spent the majority of your career there, and that's kind of what you know. There may not be a lot of those types of jobs available to you. So there are a lot of tough conversations you've got to have with yourself and your family.
That's true, and it's sad. And if you've worked someplace 30 years and haven't done anything else, and don't think you can find another job, that actually helps your workers' comp claim, but that's a bad situation to be into.
Right.
Am I qualifying for Social Security disability in addition to workers' comp? Those are some really hard decisions you have to make. If you're younger, you might be eligible for vocational rehabilitation, which means retraining for a certain period of time through the Workers' Comp Act. There's other vocational rehabilitations outside of the Workers' Comp Act that might be available too. But those are some hard choices and some hard decisions, and there's not a whole lot that can be done to make those better.
Well, especially if you're getting up in age and you're 50, 55 years old. I mean, the options are fewer.
Well, and as we get older, we don't bounce as good as we used to when we fall down. And what used to be a small injury is a big injury. And if you do go back to work, you're not working as fast, and things happen. And it's not a good situation. But I think it gets back to the original thought that, you got to take care of yourself. You may only have one shot to get what you can out of this, and you want to make sure it's set up properly. And, if you do have that situation and the company's manipulated this claim in a certain manner to where it's going to greatly reduce your benefits, well, you've not helped yourself at all, but you've made somebody at the company a lot happier.
Right.
And for a lot of folks, they only have one shot to get what they can out of this. And, the more serious your injury, the more important all this becomes. If you've got a job-ending injury, if you think you're going to have a hard time going back to work, then you need to really be asking yourself these questions.
Well, it may be time to lawyer up, right?
Well, it is. That's the
bottom line, isn't it?
Yeah. But I mean, in those kind of situations, you don't have a choice. When do you lawyer up? Well, if you've got an injury that looks like it's going to be serious. If you've got something that's stubbed toe and it's going to be okay tomorrow, you don't need to lawyer up on that. But, if you've got something that's going to result in a permanent problem, if you've got an injury where they're not paying you for being off work, if you've got an injury where they're not paying for the medical treatment, you don't have a choice, really. Yeah. But in those situations where it looks like you got a serious injury, and especially as we get older and your chances of going back to work diminish, then you really need to get an attorney sooner as opposed to as later. And again, at the very beginning of these cases, sometimes they're managing the outcome. And the people that have been doing this for a living at HR, safety directors, workers' compensation carriers, they're trying to manage the outcome at the very beginning of most of these cases. And if you've got a serious injury, you also need to manage the outcome. And what you need to do
that's a great way to put it.
Yeah, you need to make sure you get the treatment you deserve, essentially, is what it is.
Yeah. Well, how soon should someone who's injured reach out and contact an attorney? I mean, is there kind of a rule of thumb, or is there?
I would call as soon as I can. Basically, your number one duty after a workers' compensation injury is to tell your employer you've been injured. You've got a duty to report it, put them on notice. And that
has to be a supervisor or somebody up the chain. It can't really be a peer. It needs to be someone higher on the chain.
Right, and I'm assuming that we've already gone through the medical treatment. If you've got a broken leg, you've gone to the hospital and seen the doctor. But if your boss wasn't around and you got taken by ambulance to the hospital, you need to put your boss on notice. You need to get the medical treatment you need first of all. But then after that, you got to put your boss on notice. But you need to get some information as soon as you can. Give us or somebody else a call to try to figure out where this might go and what you need to do. If you're not read up on workers' compensation and you don't know you've got a right to a doctor, then you really do need to talk to an attorney, because there's a lot of other things that go on in these things. There's future medical treatment, there's future impairment ratings and money that's available to you, and all that's being managed at the very beginning of these cases. And again, there's folks that do this for a living in a lot of plants.
Yeah, it's kind of a kind term when you say they're managing it. There's a few other terms that might be more appropriate, in a different venue.
We're not going to get into those here right now, but I've seen some here recently. I've really actually been impressed by the employers and how they've managed some outcomes from the very beginning of these cases. And, people don't want to do something that makes their employer mad, but get an attorney involved. People don't want to act like they're being unloyal. And at the end of it, they're out on the street and they made their employer happy, but they're the ones that have really been taken advantage of. That's the only way I can describe it.
The employer's probably still laughing, unfortunately.
Well, they know what they're doing is what it boils down to. And if they've done this a couple times, they know what they have to do to save money. Most people never have had a workers' comp claim before and don't know what's going to happen and how things are important at the beginning, might have a big outcome at the end. And the more serious your injury, the more important it is to get involved somebody that has some experience with this. Let you know that you can pick out the doctor you want to go to. Let you know that you have all your medical treatment available to you, that you get reimbursed for mileage expense, that, if you have a permanent problem, you get money even if you go back to work at your employer. If your employer is asking you to ask the doctor to take away your restrictions, that may not be in your best interest.
Right. Well, if you don't heal properly, you're going to have longer problems down the road. Those are going to last. They're going to reoccur. They're still going to have a ongoing issue for you.
If you have a permanent injury, if you have a permanent injury, you really need to get an attorney involved in this as soon as you can.
Yeah.
With that permanent injury, there are so many other things that come into play down the road. Right to medical treatment. For instance, in Kentucky, you have a right to medical treatment for the rest of your life. You may have to fill out a form and get that after 15 years, which they've just passed in the last couple of years. We'll see what happens as they work with this. But, for instance, in Indiana, you don't have a right to future medical treatment in most cases. Once you reach maximum medical improvement, it's over. So, laws are different from one state to another. Medical treatment's changed since I've started practicing. When I was originally practicing, they didn't do knee replacements. I can't remember ever dealing with that till I've been practicing for 5 or 6 years. That's a pretty common surgery right now.
Right.
We've got 2 or 3 cases involving knee replacements right now. Other things have gone on. I guess they can replace any part of any joint of your body. Shoulder replacements. There's therapies that weren't available 10 or 20 years ago. Spinal cord stimulators. Things like that. There's new medications that come out all the time. Medicine does progress and gets better over time. In general, most of these new treatments cost money, and usually because they're newer, they cost more. If you've kept your medical treatment for the rest of your life, then that's stuff that you can get down the road, and workers' comp can end up paying for it. A lot of times the carriers will offer folks money, $2,500, $5,000 to waive that right. And it's a gamble. For most people, it's something they really need to look at because, number one, the insurance company is not usually going to offer that money unless they think it's a good deal for them. So certain injuries, especially back injuries, knee injuries, shoulder injuries, might require treatment down the road. And you have to be very, very hesitant to waive those kind of future medical expenses. If you have a real serious injury and you qualify for Social Security disability insurance, after a certain period of time, you'll also qualify for Medicare. And if you don't take care of Medicare in your settlement by doing what they call MSA, a Medicare set-aside, or if you don't do it properly, you can run into a lot of problems with Medicare down the road too. So there's a lot of loose ends that have to be tied up. The bigger your case, the more important all this stuff is, and the bigger the problems can be. But bottom line is, if you've got a permanent problem, if you think you have a permanent problem, if it might be a permanent problem, call up somebody that deals with this. I handle these on a contingency fee basis, which means I don't charge you any money unless I make money for you. We have to charge fees sometimes to get those recovered later on too. But at the very beginning of the case, I'm not going to charge you to talk. And if we handle the case, I'm not going to charge you anything until we get money for you. It doesn't cost anything to call me. Most other attorneys that handle them on the same way on a contingency fee. So it's a free call basically at the very beginning of these cases. I talk to folks all the time. I talk to folks and I'll hear back from them sometimes 6 or 9 months later. But if you've got a permanent problem, you do need an attorney. Sooner or later, and you might as well get it sooner because that will help speed up the case. We'll get stuff going that would be needed later on. We can give you advice, and we can talk about some of the situations that come up. And if you're going to hire an attorney, you might as well hire them at the beginning and try to get as much help as you can throughout the case, as opposed to the end of it.
Well, because that could have a bearing on the types of medical examinations and tests that you're able to get while you're trying to diagnose or treat.
Yeah.
It could have an impact on the medicine you're able to get, all these different things, right?
Well, I tell folks in general, if you call me and you want me to represent you, it still takes us a while to get set up to take care of that. We got to get your medical records. We got to get letters out to the insurance companies, employers, and stuff like that. We've got to figure out what's going on with you. You tell me what's happening, but I still got to look at the medical records. Some people have those with them. Most people don't. And if we got to request them, sometimes we can take 5 or 6 weeks just to get those records, and then we have to look at them. So it can take a while to get going on a case.
Right.
And even if you have things going pretty good, at the end of it, if it's going to be a permanent problem, you really do need to get an attorney involved in it, because there's a lot of little different things that you don't think matter that really do. And if you've got an attorney involved at the beginning, they've got all your medical records up to date, you've saved a couple of months' worth of time, really, to get your case resolved. Now, you still may have to file a claim. You still may have to go through the litigation process. But a lot of cases we settle, and you're in a lot better position to settle when somebody's got all the information in front of you. And it takes a while to get the information. So,
right. And Scott, what's the best way for them to kind of get a hold of you? If somebody's listening to this and goes, you know what, I may be dealing with that.
Yeah, the best way to get a hold of me is to call my number at my office, which is 502-937-5287, and you'll speak to one of my staff. They will get some information from you, and I will generally try to call you back. I try to call people back at least within a day. Sometimes it's not that fast if we're real busy, but I'll personally try to call you back. You're not going to be dealing with a paralegal. You'll talk to an attorney, and we'll talk about your case. There's other ways to contact me, too. I do have a website, ScheynostLaw.com. Again, you have to be able to spell Scheynost, which is the hard part. There's a way you can contact me through the contact page. We have a Facebook page, too, and you can send me a message on Facebook. But if you get a hold of us, we will try to get back with you within 24 hours, if not immediately. And we'll talk about your case and try to figure out what needs to be done.
Right. And friends, if you're listening to this, I'll make sure that in the show notes, which are just in that group of paragraphs right below the recording of this episode, you'll see the link to the website. You'll see the phone number and everything there. So if you're listening to this podcast episode right now, I'll make that very easy for you to kind of reach out and get in touch with Scott. Scott, a couple of other things. You had mentioned that on a contingency fee, it doesn't cost them anything to reach out and call you, and you'll do a consultation there and kind of discuss the case a little bit with them. Let's assume they hire you, and again, you're fronting some of that expense. So maybe there's some other things that you as the law firm actually are going to pay for in advance. And how does all that work out?
Yeah, we typically incur costs when we handle a claim. We've got to get reports from doctors. We've got to get medical records. Sometimes there's deposition and hearing transcripts we've got to pay for. So there's typically some costs involved with every case. Normally, we will forward those costs, which means we'll pay for them at the beginning as we incur those costs during the course of the litigation or the representation. Then at the end of the case, what we'll do is we'll take our fee out, and then we will also take out the costs and be reimbursed for the costs. So what that means essentially is it doesn't cost you anything to contact me, and it doesn't cost you anything until the end of the case as far as the actual expenses.
Right.
So, that makes it a lot easier, I think. It really, there's no upfront cost for most people to come in and talk to us and represent them.
Right. And, of course, lawyers in Kentucky are required to say that court costs and fees are the responsibility of the client. What does that mean, and how does that work out at Scheynost Law Office?
Yeah, in my office, we have the same agreement where the client's responsible for the cost. My personal policy is that we won't recover those costs if we've lost your case. Or if we don't recover anything for you.
Right.
In general, we're not going to be in cases, though, where, that situation occurs. So if you've been honest with me, we're not going to recover costs from you. And essentially that means...
the risk is very, very low.
Exactly.
You've been doing this for a couple of decades now. And
I don't want to...
You've got a lot of experience in these cases.
I do have gray hair where I have hair anymore. But we have done this for a while. I've seen them change the workers' comp law about 5 or 6 times. I'm sure they'll change it again in another year or so. We do have a lot of experience with this, going all the way to the Supreme Court with cases. We handle this pretty regularly. I've got several folks in my office, and I've done this for a while. It's been what we do. We enjoy working in it. This is a big part of our practice, if not the major part of it.
Right. Well, in continuing with the theme of when do you lawyer up, there's something that we talked about in the previous episode 11. We talked about the statute of limitation. You want to talk about that real quickly in just a run-of-the-mill workers' comp case? Because, people need to be aware of this.
Yeah. In a traumatic workers' compensation injury where you run over, say, by a forklift, there's a 2-year statute of limitations. There's other statute of limitations for exposure to disease and repetitive motion, and we're not going to go down that road. For most people that are involved in a traumatic injury, there's a 2-year statute of limitations, and that 2-year runs from the date of the injury or the last date they received temporary total disability benefits for being off work because of the injury, which we call TTD, whichever's later. So if you get hurt at work on January 1st and you're never off work and never get any money, you've got 2 years from January 1st till January 1st, 2 years down the road. If you get hurt on January 1st and you're off work for 6 months till June 30th, and you receive TTD during that time, then you've got 2 years from June 30th to receive benefits.
Right.
And again, it's different statute of limitations for other actions, third-party claims, but for workers' compensation, traumatic injuries in Kentucky, it's 2 years from the date of the injury or the last date of payment of temporary total disability benefits.
But again, as you said earlier in this episode anyway, that the more severe the injury is, you probably need to lawyer up a little bit earlier in the case because there's a lot riding on this.
And I'll be honest with you, if the statute's going to expire tomorrow and you walk in my office, I probably can't help you.
It's almost too late.
It's too late because, like I said before, we got to get your medical records together. We got to see what's going on. And that takes some time, and you don't want to wait. You want to get things going. I think the worst thing you can do for yourself is call somebody up and say, "Hey, I've got a statute running tomorrow," and I'll be honest with you, I don't think I can even look at it because I'd have to drop everything else I've got going on. It's not fair to my other clients. It's not fair to you either, really. Yeah. You really need to get this taken care of ahead of time. And the sin of it is if you don't, it's just so easy. It's a phone call, basically, to see if you've got a claim and if it's worth pursuing. It's just very, very difficult to get everything in order, the forms signed, ready, medical records, all the supporting documentation together for the claim. So even though you've got a day or so to file it, it's still probably 2 or 3 good months worth of prep work before you get there. And even then, that's pushing it.
Well, so the simple answer is the earlier the better.
That's when you lawyer up.
Yep. Yeah, it really is. Scott, I want to thank you again for your time. I know you're busy. I know you've got a lot on your plate because we talk fairly often. And we talk about your practice a lot, and it's your practice has been doing just very, very well. We just talked about updating some of the settlements and awards on the website. I'd always encourage people to take a look at that. You know what you're doing. You've done this for a long time, and you're out there on Dixie Highway, but you actually cover beyond just Jefferson County.
Yeah, we are admitted to practice in Indiana and Kentucky. Primarily, my workers' compensation practice is in Kentucky, and we've got clients all over the state, east, west. I won't go into all the places,
sure.
If you're hurt in Kentucky, we can handle it. And what's been interesting, one thing about COVID, it's actually made it a little bit easier. We were doing this before, but it's actually even easier now to handle cases throughout the state because a lot of this stuff is now done remotely. Through Zoom depositions and internet filings and things like that. But, you can be in Fulton or Falmouth and, we can still handle the case basically just like you were here.
Yeah. I mean, technology has been very advantageous for not only the injured person, but also the attorney handling the case.
Yeah, from our end of it, it's been actually a lot easier to deal with cases and clients, especially ones that are not local. Of course, it helps to have access to the internet. I know some people don't, and cell phones and stuff like that. But it's actually made things, I think, easier. There's a lot of things that could be done now that couldn't be done or could not be done as easily a couple years ago.
Well, and things are also a little bit more efficient as well.
They are, yeah.
And that's good news for everybody.
I think it helps people get their stuff resolved sooner, too. Yeah.
I think so. Well, Scott, once again, thank you very much for your time. And friends, if you've been listening to this, I really want to encourage you to, explore the other topics on this podcast. If you go to Scott's website, ScheynostLaw.com, you'll see an area on there under media where it shows all the podcasts. And you can actually listen to various episodes that have a wide range of topics in there. And I think you'll find these fairly insightful. And what I'll do is I always try to link in the show notes to other related topics. It might be a page on his website. It might be a blog post. It might be a video. It might be another episode. So again, a wealth of information there for you. But I think at the end of the day, the biggest question that you're asking is, when should I lawyer up? And I think Scott said it earlier. The sooner the better sometimes, because the companies aren't always your best friend in this situation. And while you may be doing them a favor, they're not always thinking about the same when it comes to you. So don't hesitate to reach out and contact Scott Scheynost at the Scheynost Law Office. Until next time, we'll be preparing some additional information to you. We wish you the best, and we'll talk to you soon. Bye-bye. Thanks for listening to this episode of Hurt at Work. Scott will be back in 2 weeks with a new episode. For more information, be sure to visit ScheynostLaw.com. That's SCHEYNOST law.com. You can also follow Scott's Workers' Comp office on Facebook. Until next time, be safe and remember, Scott's ready to help, especially when you and your family need it the most.